All right, hello everyone, and welcome to today's presentation titled Why Family Courts Fail Protective Mothers and Their Children, 20 Common Mistakes in Evaluations Judges Miss. Okay, my name is Ashley Rumschlag. I am the CEO and president of Teresa's Fund and domesticshelters.org. I am joined today by Rachel Myers, our digital services specialist, and Hannah Craig, our senior content strategist and creator. Both of them will be available to monitor the chat in the Q&A box today. Just a few housekeeping items before we get started. We will offer live closed captionings for this webinar. To enable, please click More in the menu bar and select Show Subtitles. A transcript will also be provided within a week of the presentation. Just a reminder that all attendees are in listen-only mode and your video is turned off. Please use the Q&A box to ask questions for the presenters. We will answer questions at the end of the presentation for the last 20 or 30 minutes and make sure you get your questions in the Q&A box. The chat, on the other hand, can be used to communicate with other attendees. And just a reminder that we will provide a certificate, a transcript, as I mentioned before, the webinar playback recording, and additional resources and the slides actually for this presentation within a week of the presentation. And we are thrilled to welcome back Katie Campbell for our next webinar. Katie Campbell works with Red Rover, and that's going to be on Thursday, April 7th, to talk about pet-friendly shelters. So any program that currently has or is considering starting a pet-friendly shelter, you are encouraged to attend this webinar. And Rachel's going to drop a link to sign up to that in the chat. All right. So if you are considering nominating someone for a Purple Ribbon Award and you are currently having a moment of panic because you're realizing that the nomination period is today, deadline is today, you are in luck because, drumroll please, the deadline has been extended. So we know you guys are just so busy and we know you have so much on your plate. Really just, helping victims and survivors of abuse. So we wanted to give you a little extra space. And so we're extending that deadline to Friday, April 8th. If you have any questions or need help submitting your nomination, send us an email at info@domesticshelters.org. We'll make an official announcement later about the deadline extension, but you guys are the first to know about this change. Just a reminder, so if this is the first time you're hearing about the Purple Ribbon Awards, this is a program that honors the heroes of the domestic violence movement. So winners are recognized at a virtual awards ceremony and on domesticshelters.org. And they also have a chance, the organizations that are winners have a chance at up to $30,000 in grants. So the nomination process is really quick and easy. We don't ask for a whole lot of information, just kind of a brief summary and some supporting documents about why this person or organization deserves to be honored. And Rachel will also drop a link to the Purple Ribbon Awards website in the chat. But you can also go to purpleribonawards.org. And again, there's our email address, info@domesticshelters.org. We love to hear from you. Please email us if you have any questions, comments, feedback. You just want to share a wonderful story about how you use the website or something amazing that's happening. We love good news. All right, so let's see. So let's welcome our presenters. So Barry Goldstein and Veronica York are both here today. So real quick about Barry. So Barry is a domestic violence author, speaker, advocate, and expert witness. He worked 21 years as an instructor in a New York model batters program and has written 6 books regarding DV and child abuse in custody cases. He has given many presentations on the issue in family courts and has been a speaker every year at the Battered Mothers Custody Conference in Albany, New York. He is currently a member of the domesticshelters.org advisory committee and a consulting expert for the Center for Judicial Excellence. Welcome, Barry. And Veronica York is a certified high conflict divorce coach and a domestic violence and child abuse custody expert. She has advanced training in family law mediation, writes articles, and performs presentations on the topic of contested custody in domestic violence and child abuse cases. She also does training for family court professionals on the misuse of parental alienation and the tactics of post-separation abuse during a divorce. Welcome to both of you. So thankful that you're here today. Barry, I do notice you're on mute. I had to mute you earlier, so you may not have noticed it. So I'll have you turn your microphone on so we can hear all the wonderful things you have to say. I'll give you a moment to do that. In the meantime, I'm going to flip to the next slide because I know, Barry, you have some things to share about. I mentioned that you've spoken at every Battered Mothers Custody Conference in New York. Could you just please share a little bit about what that is before we jump into the presentation?
I always talk about the Battered Mothers Conference as being the best weekend of the year. And we do have wonderful speakers. I will be speaking with Veronica the first night, Friday, April 29th. And on the Sunday, I'll be speaking with Kathleen Russell. They have many other wonderful speakers. And perhaps the best part is that protective mothers meet each other, find out that other women who are easy to admire are going through the same things, that there's nothing wrong with the protective mothers in these cases. It's the courts that are broken. And it's a great experience. I hope to see many people there. And we missed the Battered Mothers Conference the last 2 years because of the pandemic. So it'll be great to see everyone again.
Well, fantastic. Thanks for sharing about that. And we'll find a link and put that in the chat at some point so people can kind of learn more about that event. But I'm going to go ahead and switch over to your slides. I'll help you advance those today, and I'll turn my camera and mic off so you all can just take it from here. So one moment while
Okay, I think we're getting started. We want to first thank Domestic Shelters. We really appreciate them providing this opportunity. And I am on the advisory committee for Domestic Shelters, so I've been working with them for a long time, and they just keep getting better and better, and I really appreciate it. And what I most appreciate is that not all organizations that work on domestic violence focus on child custody, and I think that's a mistake. But Domestic Shelters has made it an important issue. Many of their articles concern child custody, and they're doing programs like this. Most of the public, including professionals who are in the court system, don't realize that the court is broken, that they may handle other cases okay, but cases involving domestic violence and child abuse are an absolute disaster. The flawed practices, which don't use current research, are tilted in favor of abusive fathers and towards risking children. And that's why it's been a disaster. And I have to tell you that there are some domestic violence organizations that are very helpful and supportive, but there are others that we've been disappointed in, that have not provided the support, that have not made child custody a priority. And this is a mistake, because for decades, we were making significant progress in reducing domestic violence, and particularly DV homicide. And that has stopped because of the success of abuser rights groups in using and manipulating custody courts to regain control over their victims and to use the courts to punish anyone that dares to leave. And we understand that it's important for women to be able to leave their abuser if we're going to reduce domestic violence. And in addition to the tragedies and the bad outcomes to individual families, the failure of custody courts to protect protective mothers and their children has resulted in more domestic violence, more DV homicides. And that's why domestic shelters need to pay more attention to the issue. There was an interesting study in Dutchess County, New York, where their court system was especially bad on DV custody cases. And this county, a very small county, less than 300,000 people, suffered like 5 domestic violent homicides in less than a year. 9 people died, including 5 women and a police officer who was killed after he rescued a child from a father who had killed the mother. And so the county legislature asked a committee of professionals to investigate the response to domestic violence in Dutchess County. And what they found was there were many problems in the county response. But one of the big problems was the custody court system. And the system was extremely biased in favor of abusive fathers. The courts were very much influenced by what they call fathers' rights groups. I would call male supremacists or abuser rights, because that's what they do. And the committee that investigated found that many women either never went to court or stopped going to court because it was easier to deal with their abuser by themselves than to have the court help him to abuse her. And that the committee found that was one of the causes of the series of DV homicides. And this is really one of the only studies that shows the effects of the failed custody court system on the larger issues of trying to prevent domestic violence. So it's important to know. So Veronica and I, we work as expert witnesses. So we review hundreds or even thousands of DV evaluations. And what we noticed is over and over again, the evaluators who are experts in psychology and mental illness, but not domestic violence or child abuse, make the same mistakes because they don't have the expertise needed for domestic violence. And even worse, the judges and the lawyers in the case also don't have the training to recognize these obvious mistakes that any of the DV advocates listening today would spot immediately. And that's why the court keeps getting these cases wrong. And so Veronica and I just try, as some work for us, we decided to make a list of all of the common mistakes. And we quickly came up with more than 80 mistakes. And we will soon have that list on our website. But we wrote an article about the 20 perhaps most common mistakes that courts make, that the evaluators make. And that's what we wrote an article about, and that's what we're going to talk about today. So that's what we're working on. Just we wanted to do the background is next. If we could switch the slide. Okay, so sorry, I'm just having a little trouble.
Yes, the background slide. Okay, so
I'm sorry, that's, yeah, no wonder. Go ahead, Veronica.
Hi, everyone. It's good to be here. Thanks for having us. So we just wanted to give a quick background on why the court system is in the situation it's in today. And Barry did a great job of doing that just now. But one of the things we want to mention is that the original sin was back in the 1970s, when the popular assumption was that domestic violence and child abuse was caused by mental illness or substance abuse. At that time, we didn't have any research to tell us different. We now know that that's not the case. In fact, most custody cases are settled amicably. It's only about 3.8% of custody cases that require trial and often much more. And 75 to 90% of those cases are really domestic violence and child abuse cases. So courts are treating these cases as high conflict. This is problematic because high conflict approaches give a false equivalency between an abuser and the victim. And so the term high conflict either needs to be changed in the custody courts, or we need to educate the courts that it only takes one person to be high conflict. So these same common mistakes are being made over and over again. And as Barry mentioned, we quickly came up with over 80 when we put our heads together to write the article. And unfortunately, we're only going over 20 of those mistakes today, but these are the things that are going unnoticed and harming children. And now Barry will talk to you about the Saunders Study.
Okay, and the Saunders Study is peer-reviewed scientific research from the National Institute of Justice. So we're talking about the most credible kind of research. And the purpose of Saunders was to review the domestic violence knowledge of judges, lawyers, and especially evaluators, because judges and lawyers get much of their information and too often misinformation from evaluators. And so Saunders found that court professionals need more than generalized knowledge about domestic violence. They need knowledge about screening for DV, risk assessment, post-separation violence, and the impact of domestic violence on children. And professionals who don't have that tend to focus on the myth that mothers frequently make false reports, tend to focus on unscientific alienation theories, and that leads them to bad recommendations and bad decisions that harm children. Now, in terms of risk assessment, there are certain specific behaviors that are connected with a higher risk of lethality. There are things like strangulation, hitting a woman while pregnant, forced or pressured sex, threats of suicide, homicide, or kidnapping, harming animals, the belief that she has no right to leave. And the point is, I've read over 1,000 evaluations, and not once have I seen an evaluator say something like, the mother claims the father was strangled her. If that's true, he's at a higher risk of committing homicide. Because the court ought to know that, but it doesn't get discussed because none of the court professionals understand the connection with risk assessment. Post-separation violence is two parts. The first part is the custody case is a continuation of his abuse. And he continues DV with things like litigation abuse, economic abuse, fathers who had little involvement with the children demanding custody as a way to regain control. And they will use other tactics. And the courts aren't thinking of that as a continuation of domestic violence. The other thing is, he abused the mother for reasons that have nothing to do with anything she said and did. You know, when I taught in a batterer program, we would always tell the men, no woman can cause a man to abuse her. And that's really important because in court, so often they want to blame the woman or blame both parties equally when it's 100% the abuser's fault. And the point of that is, if he gets custody or unprotected visitation, he will inevitably abuse his next partner, which will expose the children to more abuse, which means they can't heal from the ACEs that they've already suffered. And we'll talk about ACEs next. So that means they're going to suffer the consequences of ACE. Now, screening for DV is two parts. The first is there are several non-probative behaviors that courts routinely use to discredit true reports of abuse. And let me give you 5 common examples. She leaves and doesn't come back. And returns. She seeks a protective order and doesn't follow up. She doesn't have a police report or medical records. And the 5th is somebody, a professional oversees a father interacting with his children, and the children don't show fear. So they say, aha, he can't be an abuser. When in fact, the children know he's not going to hurt them in front of a witness, so it's safe to play with a father they still love. But professionals discredit reports of abuse based on these common situations that are not at all probative. All of them are based on safety and other concerns. So the impact of DV on children is ACE. So you'll hear about that shortly. And
Ready for the next slide?
the fundamental in a second, one last thing. Fundamentally, without Saunders, courts fail to recognize reports of abuse, true reports. And that means they're going to get cases wrong. Now, Veronica's turn.
You said ACE, and so I thought we were heading north. Okay, so along with Saunders, the main body of research that we use in courts is ACE. Courts need to understand what ACE is. ACE stands for Adverse Childhood Experiences. It's peer-reviewed medical scientific research, highly credible, done by the Centers for Disease Control and Prevention. Without ACE, courts are minimizing the harm that domestic violence and child abuse is having on children. Most domestic violence is neither physical nor illegal. So most of the harm is not the immediate physical injuries, but it's actually the stress and fear that children are living and the mothers are living with. Exposure to ACEs means that children will live shorter lives and have a lifetime of health and social problems. These problems can be low self-esteem, anxiety, depression, suicide. So without ACE, courts are really relying on professionals who don't understand domestic violence dynamics or batterer narratives, which is what Barry was just talking about. And without ACE, it's hard to explain abusers' motives. So we really want to use ACE and Saunders to change the discussion in contested custody cases to what can the father do to reduce the fear and stress on the children and the mother they depend on, rather than what they tend to focus on, which is what can the mother and children do to accommodate the abusers' behaviors. So on the next slide, Barry is going to talk about why we need domestic violence experts.
Okay, and I just want to mention, I like to tell courts that the National Council of Juvenile and Family Court Judges, which is a very highly respected judicial organization, seeks to train other judges about ACE and Saunders. And that's important because it will make the judge more willing to listen to ACE and Saunders. So it's important. Okay, why do we need DV experts? And there is now a specialized body of domestic violence knowledge, research, and experts. And the courts don't get that unless they have DV experts. One of the things we do, as we talked about a moment ago, and as we're going to talk about throughout this presentation, is that we will help the court to recognize mistakes that evaluators make, because the courts have spent their entire careers listening to misinformation so that they don't even know when the evaluators are making just fundamental mistakes. And you'll see when we talk about them that these are things that occur frequently, and that, again, any advocate in a DV shelter would know is wrong. And Saunders said that we should use a multidisciplinary approach. And that makes sense. I mean, who can argue with that? You know, mental health professionals are expert in psychology, they're expert in mental illness, they're not expert in DV and child abuse. And what tends to happen is they'll focus on the areas that they understand, that they're comfortable with, and so they shortchange issues around domestic violence and child abuse. And that's a real problem. It's the DV advocate experts who can give the court the information they need to recognize domestic violence and to talk about the best approaches to respond. And DV advocates have more than the specific knowledge. You know, they bring the context, they bring the patterns. That's how we come to understand it. And Saunders specifically found that judges, lawyers, and evaluators have substantially less domestic violence knowledge than DV advocates. And, you know, I must tell you, for decades, DV advocates have been saying physical abuse is not the worst part of domestic violence. And no one else was listening to them or believing them because they didn't have fancy degrees after their name. There wasn't research to support what they were saying. They were seen as biased because they're always against domestic violence. Imagine that. And most of all, they were only women. And so one of the interesting things about the ACE study is it confirmed everything the domestic violence advocates had been saying for decades. They were right. They understand this better than any other profession because they're the only profession that works full time on DV issues, on preventing domestic violence. And it was really disrespectful that courts were not listening to them. And so when we talk about ACE and Saunders, there are many standard court practices that ACE and Saunders tell us are a mistake. And so when courts try to make decisions in DV and child abuse cases without ACE and Saunders, they are likely to get it wrong, and they do over and over again. And one thing that's important here is failure to use ACE and Saunders is not neutral in the sense that it applies equally to both parents. All of the mistakes from failure to use ACE and Saunders favor abusive fathers and tilt courts towards risking children. And that's the problem. Veronica.
Okay, so as Barry said, we quickly came up with several mistakes evaluators use, and one of the ones we said first was that they don't consider. They think public behavior says everything about private behavior, when most abusers can actually behave in public. And I think Barry even mentioned children know that their abuser is not going to abuse them in front of witnesses. So opposing party, opposing counsel, likes to bring in character witnesses to talk about the status and the community of the abuser, how wonderful he is, and what a great guy he is, and all of the wonderful things that he does, and how they can't believe he could do something like that. Unfortunately, evaluators rely on this non-probative public behavior to conclude that there's no abuse going on. But victims and children know that the private behavior is not the same as the public. Another big mistake that is made is, again, most domestic violence is neither physical nor illegal, but evaluators like to focus on only the physical. As Barry said, advocates have known that that's not the problem for a long time. Domestic violence is not about inflicting the most physical pain. It is all about control, coercing and controlling their victim to do exactly what they want them to do. So for decades, advocates have been saying this, and we need to start listening to the domestic violence experts in custody cases. Specifically in custody cases, we need to be looking at the impact that the abuse has on the children and the stress and fear that it's causing. Failure to realize that the harm is caused by the stress and fear is the thing that's hurting children the most. So the best use of the ACE study that we talked about is prevention. Oftentimes, contested custody cases are the last chance to save these children from the horrible consequences of ACEs. So not considering ACEs really reduces the amount of domestic violence evidence in these contested custody cases, and courts are minimizing the harm that's caused. Assuming that unfounded CPS cases mean that reports of abuse are false is not only a huge mistake evaluators are making, but it is also an example of gender bias in the court. CPS workers are often overworked. They lack the experience in domestic violence and child abuse. They are pressured to open and close a case within 30 days. So due to non-probative reasons that Barry mentioned before, things like the fact that you're actually in a custody case, a child may not be talking about the abuse or making outcries. The abuser has bullied the caseworker and manipulated them. And a big one is they believe the myth that mothers frequently make false reports. And all of these things are assumptions that cause true reports of abuse to be ignored. Barry will take the next slide.
Okay, and Veronica and I want to mention that we put these examples of evaluator mistakes into the article, trying to make it available to everybody, because we think that protective mothers and professionals can use this in their cases, because it's not a mother in an individual case saying, what this evaluator did is a mistake. You can now say, there is an article by one of the experts who says this is a common evaluator mistake, and this evaluator made it in this case. And I think that's will make it easier, for the court to listen and to recognize it. And we hope that, this information will be shared both within professional circles and among protective mothers and within the DV movement, because, all of this would help get better outcomes. Okay, so we're going to continue talking about this common mistakes that evaluators make. And as we were talking about earlier, one is that most evaluators have failed to consider ACE and Saunders. And this is fundamental, and let's say it out loud. When an evaluator doesn't use ACE and Saunders, they're committing malpractice. They cannot recognize all or most domestic violence tactics without Saunders, and they routinely minimize the harm without aids. So it's really important to them to have that. And, like if you're in a case and they didn't use ACE and Saunders, your attorney can cross-examine the evaluator. Are you familiar with ACE? Are you familiar with Saunders? Would you think that something that the National Council tries to train judges about would be highly credible? Would you think something from the CDC and the National Institute of Justice would be highly credible? And you can talk about some of the specifics in Saunders and ACE. Do you agree with that? And if they say they don't, then they're disagreeing with the leading experts in their field. And if they agree, then they made their recommendations without considering this information. So it's a really good way to undermine the evaluators when you need to do that. The next thing is that they routinely blame mothers for the father's abuse. And this is a form of gender bias, which is very common in the courts. And one of the things that makes it difficult is that it's usually unintentional and subconscious, but it impacts the outcomes, which is why we need to speak about it. So when the evaluator is talking about, the mother's afraid of the father, the mother's emotional or angry, the mother is doing things to try to protect the child, all of these things that they might view as uncooperative are really a normal and proper response to the father's abuse. And they're missing that. And let me just say something else out loud. In Saunders, they say that courts often take mothers' anger and emotion all out of proportion to what it says about her parenting. So that's a common situation. And so if you're in a case where you have gotten upset and the professionals are treating that as if there's something wrong with you, it might be useful to quote Saunders on that. Okay, fail to recognize shared parenting is inappropriate in DV custody cases. And again, this is in Saunders. He specifically says that you shouldn't consider you shouldn't consider shared parenting when there's domestic violence or child abuse. And fundamentally, when there's domestic violence, then there's an uneven situation. One party is afraid of the other. They can't have an open discussion about decisions because the mother is afraid of the father. And sometimes courts or the professionals will try to say, well, we haven't concluded that there's DV. But it doesn't matter. If one of the parents thinks that the other one is abusive, they're not able to cooperate, communicate. That's not a case for shared parenting. And so it shouldn't be doing that. And finally, it seems like it's standard practice, and it's a lot of it has to do with high conflict approaches, and it has to do with the courts needing to create settlements which are based on not what is best for the child, but what they can pressure usually the mother to agree to. And so very often the courts are focused on pressuring the mother to accommodate the father's abuse instead of focusing on, as Veronica said, focusing on how does the father reduce the fear and stress that he's causing. And the reason that our approach is better is because it's better for children. And it's also helpful when we present these cases that we are trying to focus on the child, because the court's more likely to listen to that kind of argument. Veronica, you want to do the next group?
Yes. So courts are assuming that evaluators are effectively screening for domestic violence, but Saunders found that they're not doing so. We now know that domestic violence is not caused by mental illness nor substance abuse. So when evaluators were asked how they screen for domestic violence in the Saunders study, they said they were using psychological tests. Well, this tells us nothing about domestic violence or child abuse. In fact, it tells us more about the ignorance of the evaluators on the subject than the circumstances and facts of the case. Saunders also found something in his study called a harmful outcome case, and he says that this is always wrong. A harmful outcome case is when an abuser gets custody and a protective parent is given either supervised or no contact with the child. These outcomes are always wrong, and they're always got to this assumption by relying on very flawed practices. A child's primary attachment figure is the person or parent who provides most of the child care the first 2 years of the child's life. So a child's success and well-being in life is really dependent on the relationship that they have with their primary attachment figure. So denying them a normal relationship with their primary attachment figure is devastating for children. And now it's been a decade after we've had Saunders come out, and courts are still failing to use this research, which is causing devastating consequences for children in contested custody cases. Another one is evaluators often discredit true reports of abuse on assumptions. Because they have no knowledge of domestic violence dynamics, they view victims' actions as indicators that there is no abuse, when in fact, most of the actions, and Barry touched on these before, that are non-probative are done because of safety and other good reasons. And again, these can include things like the mother didn't file for a protective order, they left and came back, there were no police reports, there aren't physical bruises, these things are non-probative. Another one is that children, because of this mistake, children have been murdered because of the assumptions that judges and evaluators are making. And this particular assumption is that just because the abuser hurts the mother, that they will not hurt the child. In fact, fathers who abuse mothers are 40 to 60% more likely to abuse their children. And they have no problem hurting the children in order to hurt the mother. So now, unfortunately, there are several children who are dead because of judges who made that assumption. And we have laws now that we're trying to pass in, we have Grayson's law in Florida, Caden's law in Pennsylvania, and Kira's law in New York, because that particular assumption was made in those cases. All right, Barry, you can do the next one.
Okay, and just to say something out loud, expert witnesses are the only witnesses who are allowed to give their opinions. And courts tend not to make a distinction between subjective opinions and objective opinions. And some of what Veronica was just talking about was an example that the evaluators are giving their subjective opinion. And that's easy for an expert. They say whatever they believe, whatever supports their client. They don't have to know the research. When Veronica and I testify, we use objective opinions, which is based on good scientific research. And if you think about it, it's much better for the courts to get objective opinions, because what often happens now is that a lot of the subjective opinions that the evaluators are using are disproven by the scientific research they're unfamiliar with. And that's a problem. So the next point here is, it comes directly from the Safe Child Act, because evaluators fail to make the health and safety of children the first priority. And, what else could possibly be the most important thing in custody cases? And, when we speak with legislators and we tell them this is the first part of the Safe Child Act, the most common reaction is surprise that that's not already the law. And the fact that it isn't, demonstrates what's wrong with the courts. Okay, the next thing is the evaluators fail to understand the significance when a mother has PTSD or a child has PTSD as a result of the father's behavior. Sometimes you might compare PTSD with panic attacks, and sometimes PTSD causes panic attacks. But panic attacks can be caused by something benign. For instance, if someone was afraid of public speaking, doing what Veronica and I are doing now might create a panic attack. But PTSD can only be caused by the most horrific events or a series of traumatic events, such as you have in domestic violence. And what that means is, if a father's behavior was so bad as to cause PTSD, he is an unfit father, period. That should be the end of the discussion. The fact that a mother or child has PTSD because of the father should be the end of the discussion, but evaluators don't seem to know that. The next thing is lethality, and we talked about that a little bit earlier. Evaluators are not considering factors that are associated with a higher risk of lethality. They're not considering it because they're not familiar with it. Again, any DV advocate knows the connection between these behaviors and the risk of lethality, but evaluators who are doing a psychological approach don't have this knowledge. And the final thing, which is really interesting and is rarely discussed in courts, there is research about batterer narratives. And the batterer narratives say men who are abusers would say that it is wrong for a man to assault a woman. And then they say, except. And the most common exceptions are, she did something that he defines as improper, and so that gives him permission to hit her. And the other is, she is insert the slur. We don't need to use that language. I don't like to give it airtime. But these are the most offensive, sexist words. Often the literal meaning is that the woman had sex outside of marriage. But what's dangerous about this is the abuser believes that if she is, think of these words, then it's okay. She doesn't deserve any protection or consideration. It's okay to assault her. And what that tells the woman is, when he calls her that, she's in danger. And what that should mean for an evaluator, what it should mean for the court, is everything we learned as kids about sticks and stones is wrong. This language does hurt women and children, needs to be taken seriously. Veronica, you want to continue?
Absolutely. So there was a study called the Bala study, and what it found is that mothers only make deliberate false reports about 2% of the time. But evaluators are treating unfounded cases of abuse as proof of coaching, parental alienation, and the like. In fact, abusers are gaining custody 85% of the time when these junk science type of allegations are used. Child sexual abuse allegations actually have several likely possibilities. The most likely is that it's true, the child is being sexually abused. Another explanation could be there was a boundary violation. Maybe this child was exposed to pornography or a sexual act. A third explanation could be that the report was made in good faith, but it just turned out to be untrue. And the last possibility would be that it's a false deliberate report. And that's usually the most unlikely. However, CPS workers typically will find a case unfounded unless there's overwhelming evidence of abuse. And when they unfound the report, they automatically jump to false allegations of parental alienation or coaching. These are always based on assumptions rather than evidence. So courts are never told about the abuse and they're not able to protect these children. Domestic violence is about control, including financial control. And the father of parental alienation syndrome is Richard Gardner. He concocted parental alienation syndrome not out of any scientific research, but out of his own beliefs and biases. And this was the start of the cottage industry, where lawyers and mental health professionals who wanted to make a lot of money and didn't care about hurting children ran with this parental alienation syndrome. However, parental alienation syndrome was twice rejected by the DSM-4 and the DSM-5 by the American Psychiatric Association. And the DSM is the continuum of all accepted psychiatric diagnoses. But even though, so once that happened, they try to change the name of parental alienation syndrome to alienation or parental alienation or gatekeeping or enmeshment, or they use all kinds of different names. But regardless, these theories that have been rejected by the leading professional organization are still taken more seriously in courts and custody courts, and have more influence over cases than ACE and Saunders, which is the highly credible research that Barry and I have been talking about today. So not only is parental alienation junk science, but it's also applied in a gender biased way in the courts. There was a study by Joan Meyer called the Meyer Study. It was done by the Institute of Justice. She is a law professor at George Washington University, and her study found that only abusive fathers are benefiting from the findings of parental alienation, or fathers in general. Meaning that if a father is found to be alienating, it has really no bearing on the case. But if a mother is found to be alienating, it makes a huge difference on the custody case. And this is really a violation of due process and equal protection. The use of parental alienation also raises many ethical issues, and it can create an appearance of corruption in the court. And this is all leading to the extreme decisions and the harmful outcome cases that Saunders was talking about, based on unscientific alienation theories, and it's causing catastrophic harm to children. Next, regarding child sexual abuse, our nation really handles allegations of child sexual abuse really poorly. In fact, we're allowing 1/4 of our children to be sexually abused by the time they're 18. And courts simply do not want to believe that a father would do this to their child. But when a child will not make an outcry, it leads to allegations and findings of coaching and parental alienation and the things we just talked about. So the best practice in cases like where there is allegations of child sexual abuse is to put young children in play therapy. And this is a best practice because play therapy can help children reveal trauma and other things that they need to reveal through their play and their artwork. But unfortunately, fathers use decision-making to block therapy, and these things are being ignored by the courts. And finally, if I could wave a magic wand and take 3 words out of the vocabulary of court professionals, it would be get over it. The get over it approach in domestic violence doesn't work, and it will never work. Courts actually have the power to force children to spend time and have unsupervised visits with abusers, but they do not have the power to take away the stress and the fear that it causes. What this does is it puts our children in survival mode, and they push down all the trauma and feelings, and then it comes out in much more harmful ways later. And this is what we're trying to avoid by letting the courts continue to make these mistakes over and over again. Barry, I'll let you conclude our presentation.
Okay, thank you, Veronica. So the reason courts have turned to mental health professionals, the reason psychologists are doing psychological tests is that they thought that domestic violence was caused by mental illness. And the psychological tests were not meant for the populations seen in family courts. People who need these tests usually need to be hospitalized. It's for really severe mental illness. And so what often happens is both parents are shown they don't have that level of mental illness. So therefore, there's no reason from the psychologist's point of view to stop either parent from having a normal relationship with the children. And they don't understand. They're not doing anything about domestic violence or child abuse. Men who are perfectly healthy mentally, but just have beliefs that they're entitled to control their partners and they're entitled to use a variety of awful tactics, they get by because the evaluators are looking for the wrong thing. The next thing is evaluators keep making mistakes that are DV 101. They're mistakes, as we've said throughout this presentation, that domestic violence advocates would know are wrong immediately, but the evaluators don't know it, the courts don't know to challenge them on it, and so they keep making the same mistakes, and the consequences are really dangerous. And what we've been saying throughout this presentation is there are all these mistakes that evaluators are making, including that the evaluators are teaching bad things to the judges and lawyers who think they're the experts. And our children are just paying an awful price for continuing with this misinformation. And it's like the courts developed these practices when there was no research. We now have the research. The research could be used to save these children. But the courts, either because the professionals enjoy all the money they're making using bad practices, or because they don't want to admit they've been using bad practices, have been really reluctant to make the changes. In the Bartlow study, which is a study about the response to child murders, these are the most unbearable crimes. And when Dr. Bartlow asked judges and administrators, what have you done in response to the tragedy in your community? Their answer was nothing, because they all thought it was an exception. And when they think it's an exception, that's an excuse not to make the changes that are needed. So that if the courts won't make the changes, the reforms, in the face of these terrible child murders, the legislators have to, because otherwise our children keep suffering. And finally, as part of the research for my Quincy book, I interviewed medical doctors working with the ACE research. And I asked them the question that is the most important in cases like these. And that question is, when a child has been exposed to multiple ACEs, is there something we can do now to save the child from the awful consequences? And their answer was yes. And the problem is that standard court practices prevent courts from making the changes these children need if they're going to live a full life, if they're going to live a healthy life, if they're going to reach their potential. To say it another way, these contested custody cases that we've been talking about today represent the last chance to save the children involved in these cases. And that's why we do this work, because we want to change the outcomes that are so harming children. We thank you for your attention, for your interest, and we've left time so we can answer as many questions as possible.
Wow, thank you guys so much. I just want to say, kind of made a note here, just great job breaking down such a complex and, I mean, really frustrating issue. I know that we've kind of seen in the chat people sharing stories of what they're dealing with currently. I've received some emails beforehand of people sharing stories. So just a great job trying to make sense of this all, because it doesn't make sense, I think, to most people on this call, because we understand domestic violence and dynamics of it. So to be able to just plainly put that out there, I really appreciate that. I know you said the list spanned, what you said, 80, but you kind of distilled it down to 20. So there's more out there, I can tell. All right, so we have the contact information for Barry and Veronica up there, but we'll also share that afterwards. I'm going to go ahead and stop my screen share here. And I know that we've been collecting all of your questions into a single document. I'm going to pull that up. And let's see here. All right. So let's dive in with kind of the top question on the list. And I'll just touch on here. We will share a link to the ACE study, Saunders study, and also I made a note to have a link somewhere to the Myers study. That way everyone can kind of look at that and learn more about that on their own time after the webinar. So one of the questions that I knew was going to come up here, we definitely, a lot of the information you're sharing is from the perspective of, the male as the abuser and the female as the victim or survivor in kind of the protective parent. Can you just kind of share your thoughts on the importance of talking at it from that angle, and any cases that you'd like to maybe cite of maybe if it was ever the opposite, but could you just kind of touch on that issue or that perspective?
If I could take this, I think it was the first article I ever wrote for domestic shelters had to do with the false equivalency between men and women. And, I think it's important. I like that phrase. I think it's important to understand. And absolutely, there are men who are assaulted and mistreated by female partners, and that's wrong. And the women in those cases should face consequences, no doubt about it. But we need to understand domestic violence is a gendered crime. For thousands of years, the law and society has supported the idea that husbands were entitled to control their wives, to discipline them, to assault them. The first law in the United States about what we would now call domestic violence said that husbands could not assault their wives on Sunday. So any other time it was okay. The rule of thumb was about the idea that a man could not assault his wife with an object thicker than his thumb. The point here is that there's been a long history of society encouraging men to assault, discipline, control their wives. There is no equivalent history encouraging women to assault or abuse their husbands. As again, there can be individual women who do that, but there's no history supporting them. And they really are the exceptions. And that doesn't excuse that behavior, but we need to be clear about it. And we need to understand that this is a gendered issue. And if we don't understand that, we miss it.
Yeah. Very helpful. Veronica, anything to add to that before we go on to the next question?
No, I just think it's important what Barry pointed out is that, it's not that we don't recognize that there are women abusers. It's just that the overwhelming majority, especially when we're dealing in custody cases, we see that, fathers who are abusers just use the custody courts to continue their abuse. There's nothing more that a mother wants than to have a great father for their children, to have them, cared for and to co-parent with and to see their children have a great relationship. But when it's an abuser, it's just not possible. And then it's where we need to just protect them. And the courts are not allowing us to do that.
Absolutely. So how would one of the questions is, how would someone go about finding an expert to testify in court? And, are there programs, because I imagine there's a cost associated with that. So what are the possibilities for for advocates to get an expert to testify?
Barry, I'll let you take that.
I was going to let you. Let me start here. Several years ago, the NCADV and NOMAS and the Battered Mothers Custody Conference co-sponsored a training for DV advocates to get a certificate so they could be expert witnesses, because they already have the DV expertise. They just needed to know how do you apply it in the courts, what's the procedures in the courts. We think that would be a really good way to make it available to women, because the other thing is then women could afford to have an expert testify in court. And another advantage to that is, let me say it this way, all these years, the courts have been hearing mental health professionals who don't understand DV, and so the court keeps getting misinformation. If you could have an affordable source of expert witnesses that the courts could keep hearing the right information from people who actually know, then they could start understanding DV and making different decisions. Because when Veronica or I testify in court, that helps the client in that case, but it also helps give information to the judge and the other professionals that hopefully they will use in other cases. So, I mean, there are DV experts that are available in addition to us. There's, some wonderful people. Look within the DV movement. And, it can be a DV advocate. Generally speaking, an expert witness is somebody who, through education, experience, or training, has substantially more knowledge about an issue in the case than a layperson. And certainly DV advocates have that. I think one of the big problems is many court professionals don't think of domestic violence as a specialized body of knowledge. Most people have some connection with domestic violence. They're a victim, they're an abuser, they know someone who was. And so, they're not giving respect to this expertise that they should. And I think that's a big problem that we have to overcome.
Have you ever noticed any kind of resistance to allowing an expert, a domestic violence specific expert witness be, included in a trial? Or yeah.
The abusers don't seem to like us to be there.
Well, I imagine so, but obviously the judge would have the final say on what's permitted. Is the idea of a domestic violence expert witness being accepted as kind of a credible source for information versus the kind of the psychological approach that has been taken?
Yeah.
Well, I will add this. So Caden's law was part of the VAWA law that was just passed by President Biden, reauthorized the Violence Against Women Act, and Caden's law is part of that. Part of the provision of Caden's law is to provide or to have expert witnesses that are domestic violence experts in these cases. So that is part of the law. So I'm hoping that that's going to help push, them being more sought after and used in these cases as, we start to pass the Save Child Act and Caden's law in Pennsylvania and other states.
Fantastic. And you mentioned the idea of an expert witness training. Is that something that's still ongoing, or that we should all be fighting to kind of reprise?
I have to tell you, the reason it was being done by the NCAD at that time was someone very well, Rita Smith, and she has been a real advocate for protective mothers. And when she left NCADV, they seem to have lost interest. We had planned to do many more trainings, and hopefully we can do so again. Perhaps Caden's law will encourage something like that. And certainly DV agencies could get together and do that. We'd be happy to work with them because it's certainly needed.
Fantastic. The ideas are flowing. I think that that's a really great conversation to have kind of following this webinar. So let's go on to some more questions. There's a follow-up that actually, touching on the idea of, male as the abuser, female as the protective parent. Do these same, have you seen these principles and assumptions play out in same-sex relationships as well?
It's a difficult issue. And, when I was teaching in the Batterer class, we might touch on it briefly, but it's a different dynamic in same-sex than in heterosexual relationships. And so there's some similarities and some differences. And I don't think we have the expertise, in same-sex abuse as we have in heterosexual abuse. And so I'm reluctant to get too far into it. But I think it's, just to say it out loud, everything else being equal, in a heterosexual relationship, men have advantages. Men have unearned privileges in this society that women don't have. That part of the dynamic is absent in same-sex, but there are other factors.
Yeah, that's very important to understand. And I don't want to get too far, of course. Let me know if this is a topic that we maybe shouldn't go in this direction, because obviously we're talking about relationship with judges. But I'm guessing evaluators are more tied maybe to the Child Protective Services arm of things. But what is the best way to get a Child Protective Service person to truly see an abusive situation? And let me know, is that kind of in the vein of what we're talking about today with an evaluator? Because an evaluator is going to be someone that's, are they involved more with the Child Protective System Services aspect, or are they more once they're in the justice system, or are these more intertwined than I understand?
Veronica, something happened in the middle of the question, so I'm wondering if you can answer that.
Okay, so evaluators are typically appointed by the court to, to look at both sides and to evaluate, each parent and how that dynamic is working. CPS usually is involved when there's allegations of abuse. And so they get involved with, trying to figure out if there's abuse or not. And that's why we talked a lot about how when CPS does get involved and they come out with something that's unfounded or unsubstantiated, evaluators take that as there's no abuse. But in reality, that's possibly not the case, and usually isn't the case. So usually there is abuse. They just didn't have the overwhelming evidence that they needed to substantiate it. And, again, we talked about how they're overworked and they kind of want to get stuff off their desk. And, if they find something, that means they have a lot more work to do. If they don't, they can close the case. And so it's kind of a broken system.
So do you have any tips for, as a domestic violence advocate that, is there, is it a matter of like laying things out in a certain way or a specific way, are there any ways that you can kind of help convince a CPS person
I think it all comes back down to training. Our CPS workers need to be trained in ACE and Saunders, just like the evaluators do, so that they don't miss important things that they would normally ignore, non-probative behaviors, and making sure that they're really looking into. I think one of the things we didn't touch on is that when there's an allegation of child sexual abuse or abuse and the perpetrator is a stranger, our society comes together and we, have law enforcement involved, and we, try to get all the evidence, and we try to put this person away, and we make a big deal. But when the perpetrator is a family member, especially a father, the goal is not to get all the evidence and put this person away. It's to, okay, let's see if there's something there. Let's try to reunite the family. Let's keep them together. There's a lot of things that are done differently when it's a family member or family, especially if they're involved in a custody case. I've had clients in cases where because there's a custody case, they won't even look at the allegations.
Yeah. And that kind of brings up a topic of something that I've heard of, and maybe you can speak more to this idea that a lot of attorneys will advise their clients not to bring up domestic violence because the data shows that they are more likely to end up with at least shared custody versus losing complete parental rights. I know that that's probably a whole nother topic to talk about, but anything that you can kind of add to that from your perspective?
Yeah, if I could, it certainly shows the brokenness of the system. To some extent, that's being a bad attorney. But underlying it is, there is and I know people sometimes haven't liked this word, but just like a pretend part in the court system where they're basing everything on a lot of assumptions that are totally wrong. And, then what they want to do is punish the mother if she tries to bring reality into the discussion. That's really what's happening with that. And what they're saying is, if the mother raises her concerns about the father's abuse, which she's raising because of the harm it is to the child, and they're saying the mother's bad for trying to protect the child instead of the father's bad for abusing the mother and the child. That's just the fundamentally what's wrong with the court system, that there are all these assumptions, and some courts will at least be willing to listen and others aren't. And there's some ethical issues for attorneys. If the attorney doesn't want to raise the issue because he or she is concerned that it'll undermine his relationship or her relationship with the judge, they might think the judge doesn't want to hear that. And so that attorney has a conflict of interest, because in trying to protect his other cases, he's undermining this client's case. And an attorney shouldn't take a case if he has a conflict of interest. They're just not thinking of it in terms of conflict of interest. And it's one of the many problems with legal ethics, is like the grievance committees will jump on something if a lawyer criticizes the courts. But when attorneys fail to represent their clients as they're supposed to, that's a safe mistake to make.
And if I could just jump in real quick, probably the most common question we get asked is, do you know of any attorneys that I can go to? Do you have any attorneys I can use? Who can I? And this is going to be my next article because it's such an important topic. But what I like to tell people about attorneys is, they need to learn the research. They need to learn ACE and Saunders, because if they're saying don't report the abuse, it's because they don't understand the research and they don't know how to present it to the court in a way that the court will listen. And so when you're looking for an attorney in your contested custody case, you need to make sure that they're willing to listen to the research, they're willing to present the research, they're willing to bring in an expert witness, and they're willing to listen and fight for you. If they're not willing to do that, do not hire that attorney.
Yeah, that's fantastic advice. And do you think, if someone, like you said, it's more of a willingness than that they come in already knowing the information, right? They can be presented, you can share them information about what Saunders is and ACEs, and they can learn. It's just a matter of, are they willing to do so?
Absolutely. 100% yes. As long as they're willing to listen and learn and present it, then that's a good attorney. And that's who you want to work with. Nothing frustrates me more than to hear my clients talk about how much money they have spent on attorneys and have got nothing to show for it except for less time with their kids and not being able to protect their kids.
Yeah. We have time for one, maybe two more questions. One question that's come up is, I find that a lot of courts lean on the idea that 50-50 custody allocation is the healthiest for children. And a lot of times, Linda Nielsen's summary of 40 supporting studies, which is in the Journal of Divorce and Remarriage, is cited. What studies do you know of, if any, that show the opposite, so that if the parents don't get along, that 50-50 custody should not be awarded? Are there any studies that you can support that people can cite to kind of help navigate away from that standard practice?
One of the studies is from the Battered Women's Justice Project. Gabby Davis was, I think, the lead author, found a very different thing. But in general, there is good research that shared parenting is never a good idea because it disturbs the children. It's having to go back and forth isn't a good thing. It's constant like that. There is legitimate research that shared parenting can work under the best of circumstances. And that means both parents want shared parenting. They're able to communicate with each other. Neither party is afraid of the other, and they live reasonably close. And that should be obvious. Anything that doesn't qualify for that should not be considered for shared parenting. And the courts are promoting shared parenting. There are laws that say you would try for shared parenting, but they all have exceptions for inappropriate cases. The problem is shared parenting is not based on what's best for the child, even though they may use that language. Shared parenting is about ideology, about treating fathers the same as mothers. And, I always love to say, children don't need both parents equally. They need their primary attachment figure more than the other parent. They need the safe parent more than the other parent. That's obvious, and it gets missed. And I think a big reason for it is courts have overwhelming calendars, and they need to get cases settled. And in these abuse cases, the father is totally unreasonable. They're not going to get him to agree to anything except what he wants. So they need to find something that they can pressure the mother to agree to. And that's shared parenting. That's something the father will go along with because it's his first step. The father who had little involvement with the child, who's abusive, who should be at a huge disadvantage in the case, agrees to shared parenting, which puts him in an equal spot. And then over time, he's going to take the child away and, the child's going to lose their mother. That's where shared parenting, that's the next step. Because something like 70% of shared parenting arrangements don't last because they're a bad idea.
Yeah. Very helpful. Anything else? So we have about 2 minutes left, or a little bit less than 2 minutes left. Veronica, anything else that you'd like to add to kind of close? And Barry, I'll give you the same opportunity before we wrap up.
No, just thanks for having us. And this topic is one that is starting to get more attention, and we're really grateful for that because there have been many children suffering through having to be unsupervised with abusers. And our goal is to make sure that the research is being shared with court professionals, lawyers, judges, evaluators. And our goal is to get laws in place in all 50 states where there will be, mandatory training, evidentiary hearings in cases like this, and ways to make sure that our children are being protected.
Yeah.
So I appreciate that we are talking more about it, and it's getting more, attention, and it's well-deserved attention because it's been going on for way too long.
Absolutely. Barry, any final thoughts before we wrap up?
Well, thank you, Veronica. I enjoyed that. Thank you, Ashley. I really appreciate that Domestic Shelters is giving airtime to a really important issue because we can't change it unless we're talking about it and learning about it. And I hope that this webinar will be helpful for that.
Yeah. And I just want to obviously thank you both so much for one, being here today, but also the amazing work that you're doing every day on the ground, helping the people who need help and helping to make the broader change that needs to be made. So thank you for that. But I do just want to acknowledge the long list of questions that we didn't get to today. I just want to share that. We will, as a team, be looking at those closely and use those to inform maybe future articles, future webinars. We want to make sure that, information that is, questions that are kind of left unanswered, that we will address them in some form. So I appreciate everyone sharing those questions and appreciate everyone for coming today. So thank you again to Veronica and Barry. And just a quick reminder that we will share the recording of this webinar. So we encourage you to share that with other members of your team, people in your community as well. And then we'll also share the slides, a transcript, and a certificate of attendance with everyone who's logged in today. If you are calling in right now, please send me an email to info@domesticshelters.org with your email address. And that is for call-in listeners only. If you're logged in on a computer, we already have your email address. So with that, we'll go ahead and conclude today's presentation. Take care, everyone. Have a wonderful day.
Thank you.